Hi, Mary. Are you there? I just asked you to.
Hi.
Oh, good.
Yes, I'm here.
I'll go ahead and I'll make you host since you are the first person here. You can go ahead and transfer that to Miriam as soon as she gets here.
Okay. Thank
All
you.
right. Have you been host before?
I have not.
All right. It's pretty simple. If you click on, I'm going to go ahead and I'll admit Scott. I'll make you host, make host, change host. All right. You are now host, Mary.
Okay.
You should see if you click on that participants button on the bottom, it'll open up the sidebar.
Okay.
And there are other like prompts, but that's the easiest. I find that's the easiest place to see when people enter the waiting room.
Okay.
And then you just hit admit. And if you hover over the names of people, you'll see a more button. And if you click on that more button, you will see an option that says change or make host.
Okay.
All right.
Great.
All right. You guys should be all good and
Thank
have a
you.
good meeting.
Oh, thank you very much. Appreciate it.
Good night.
Hey, Mary, can you hear me okay?
Yes, I can.
Oh, good. It's working now.
Good.
So, see you in a bit.
Thank you.
Who is host tonight?
That would be me. I'm just tell me how to transfer to you now.
Well, how do you do it? I think you go to the list of participants
Okay.
and then
I
to
got
the
it.
right of me.
You're a host now.
Thanks. All right.
Congratulations.
Well, we can be co-hosts. You want to be a co-host? I'll make you.
Oh,
keep
okay.
co-host.
Sure. And I'll
That'll
keep an
work.
eye. I don't know if there's more people coming, but
Okay. Carrie's not joining us tonight, so I'll take the minutes. And we've got everybody. We don't have Robin, so let's wait for a couple minutes. Hi,
is
Beth.
Robin back in town?
She is back. I talked to her today.
Okay.
Get your notarizing done? I've seen some earlier emails about trying to do
Yeah,
that.
we did.
Oh,
And
good.
I'm going to be in town. I'll drop it over at Kestrel. Just save them.
Good.
It's just been a long process to get this conservation restriction taken care of.
Yeah.
All right, here's Robin. And, I don't know if we'll have members of the public coming. If we do, I'm thinking this will be an informal meeting. So if people want to have a discussion, that's great. All right. So I did a little organizing to kind of help us sort of organize our thought process for tonight. And I put together a little PowerPoint.
Oh.
So I thought you're excited. I'm glad you're excited. Let me make sure I've got all my documents open. So you can small talk. And Robin, how was your trip? While I'm opening documents, you can tell us.
Are you talking to me?
Yes.
Yeah. Robin.
Okay, I didn't hear my name, so but I was like, did anybody else go on a trip? My trip was amazing. It was so nice to
Robin.
see my daughters and my 15-month-old grandson.
Oh,
Oh,
oh.
Who
that's a
is
good
absolutely
age.
adorable. And the next time I see you in person, I will entertain you with
Oh.
videos.
Oh, how nice.
Well, he's adorable, so we
Oh.
appreciate
He'll have
that.
fun for Christmas, though, that's for sure.
I'm sorry, what?
He'll have fun for Christmas.
Oh, heck yeah, because we're all going to converge on her place, and he won't just be a few months old. He's going to be he was already tearing around the house.
Oh,
And we were in charge of him because my daughter and her husband were going off for a friend's, an old Dartmouth friend's wedding for the weekend, and they wanted us to watch him, but they wanted him to be used to us. So they insisted we go down like 10 days earlier and
Wow.
stay in their house. So he was very used to us. And he was. We had a wonderful weekend. He was like totally okay with grandma and grandpa.
Oh, that's
Aw,
great.
that's so
Bless
cute.
you.
It's
That's
the
very
best
cool.
thing. It's grandchildren are like the best thing ever.
Mm.
Absolutely the
Better
best.
than children.
Well, they are children and they're even better than children.
Right.
All right, wait till they start saying, I want grandma.
Right.
Mm.
All right. So I'm gonna pull up what I did was I thought, let's try to organize our thoughts. So I put together a little PowerPoint summarizing kind of the discussion and just a kind of then we can use this to look at the draft that what happened that Janice and I organized. So what we did was we went through the existing bylaw. And what I looked at was all of the language that is virtually the same as the MACC model bylaw, because we don't want to change that necessarily. If it's not broken, why don't fix it? And then I looked at the feedback we got from Attorney McGregor and some of the feedback we've gotten from other attorneys like Donna McNichol and Beth Goodman. And so I tried to highlight the areas in the bylaw that maybe could use updating that aren't in the MACC, that it is out of date. And then I kind of tried to craft a first stab at what would this bylaw look like if we kind of keep the existing framework and structure, but we just revise that language that we absolutely have been told needs to be revised. So I thought we'd look at that and then maybe have a discussion if this is the direction we want to go in or whether we want to look at a more comprehensive overhaul. So that's kind of like the question is sort of like fix it or overhaul it completely.
So I was really surprised at that McGregor class today, that multiple times he referred to as wasn't updating. What was his word? Let's see. They would just
Mary and I went
they
to a
would just
presentation with Attorney McGregor today for it wasn't MACC, it was the Massachusetts Society of Municipal Conservation Professionals.
he kept referring to it as beefed up, and that his own town bylaw was beefed up, and it was originally done in, what was that, 1980?
Yeah.
Which I find interesting.
Yeah.
Yeah, he was talking about the town of Arlington and that their bylaw was passed in the 80s, but that they recently issued new regulations that beefed it up.
Mm-hmm.
So
That included the climate stuff too, right? Arlington's one
in
of
the
Yes.
regulations, not in the
Yes.
bylaw. They didn't
Oh, yes,
redo the
okay.
bylaw.
Yeah,
Yes,
and that amazed me too, that he recommended it could go in regulations and not have to be going in the bylaws. Just like, okay,
Well,
I didn't think that was his opinion, but
the two case examples that he gave for good regulations were the town of Arlington's and Hingham's. And I was really happy about that because those were the regulations that we studied, or I studied. very carefully when we drafted these regulations. Like, we took a lot of language from those two sets of
Ah.
regulations. So that was just nice confirmation that he had confidence in that language. So,
Huh.
all right. So let's, without further, I'm going to screen share this. And I thought also for the recording for the public that this would be helpful. So, you know, again, some points to keep in mind that, you know, local home rule authority for bylaws is well established. But the way that the courts have ruled on bylaws is that they're really only defensible to the extent that they're more protective of resource areas and values than the Wetlands Protection Act. So bylaws don't have to mirror the Wetlands Protection Act. They don't have to be exactly identical, but they have to be consistent. That is, they can't require something that is prohibited under the Wetlands Protection Act. They can require more protections, but there has to be consistency. And the Wetlands Protection Act also, I believe, has language, or the regulations of the Wetlands Protection Act has language saying that towns may have may have bylaws that are more protective. So that's established, firmly established in state law and in court decisions. But sometimes people say, well, why don't you just make the bylaw completely mirror what's in the Wetlands Protection Act? And in that, if we were to do that, that would just eliminate the need for a bylaw, and the bylaw wouldn't really make any sense at that point, because the purpose is to have it be different. So this is the way our bylaw, or most bylaws, are organized, these sections. And almost, I looked at about 50 different bylaws. I also went through the Attorney General's municipal law department has their decisions online, and I looked at the decisions that they issued for the last 5 years where there were new bylaws being adopted. And I went back and looked at those bylaws so I could see what more recent bylaws that are getting adopted by towns look like. And, you know, by and large, they all have these components for the most part. And most of these are in our bylaw. There's a couple ones that aren't. So we don't have a section for appeals. But otherwise, all the other sections are the same. And that's because this is how the MACC model bylaw was drafted, and towns by and large have based their bylaws on that model. That's really kind of the gold standard for the statewide. So again, you know, the MACC model has not been updated since 2006, which is interesting, but yeah. But it's considered to be tried and true. It's been approved by the Attorney General, considered to be enforceable and reflecting best practices. But as we were, the training that Mary and I went to today on how to make bylaws more sensitive to climate change and climate change resilience, Attorney McGregor talked about a project with EEA and his law firm and MACC, where they had this intensive kind of legal and scientific review of bylaws from a climate change perspective. And they developed a grid, a spreadsheet with recommended changes to bylaws to update them and make them more sensitive to new science around climate change and how wetland protection can create climate resilience. So that is not reflected in the MACC model bylaw because that was just published in 2023. And it is on the Climate Smart or the Climate Resilient website. There is a link to it on our website. And if anybody wants the spreadsheet, I can email it to them. I have the spreadsheet on our town website if the public wants to look at it, but it kind of goes through a whole bunch of different things and sort of says, you know, here's the problem. This is the deficiency in the Wetlands Protection Act. This is what our recommended language is. And then here are some towns that have adopted it. Here are some examples. So that's that. So, you know, what I was looking at when looking at our bylaw is like, you know, how does it measure up and kind of what are its deficiencies? What are its strengths? And, you know, the takeaway is that most of it is identical to the 2006 MACC model bylaw language. Maybe there's little minor wording changes, but remember I sent you a version where everything was color coded in green if it was an agreement with the MACC model. I basically went through the bylaw and went through the MACC model and looked for areas of agreement and color coded them in green. And so, you know, a really large amount of it hasn't changed. I think that there's been a lot of talk about how the MACC model has become that our bylaw has become outdated, but I think that's just important to think about. So one thing that's not in our bylaw is that there's no reference to 310 CMR 10.00. So there are lots of places where it references the Wetlands Protection Act, but it doesn't reference its regulations. And it probably should have a reference like the Wetlands Protection Act and its regulations, or the Wetlands Protection Act and 310 CMR 10.00 to make it clear that it's incorporating those regulations. Because I don't think the regulations existed in 1987, did they, Janice?
I don't know.
They weren't in the MACC model at that time.
Oh, okay. So,
Reference. So
hmm.
anyway, so then there's the values, and we'll dig into that in a minute. But you know, some of the values are missing. You know, like from the MACC model, there's some new values that MACC includes, and the values are basically the purpose of the bylaw. It's the stated reasons why we're protecting resource areas. Then there's the section about jurisdiction, which is really just the listing of the resource areas. And some of the language, you know, we've had this big long discussion about how our jurisdiction section, our bylaw is a little confusing. The language about subsurface streams, not really super clear. We don't mention bank. We don't mention riverfront area, even though those are protected resources under the Wetlands Protection Act. And so that's like a confusing thing because you don't want our bylaw to be less protective. We should at least have all the resource areas that are in the state law, and then we might have some additional resource areas, but we shouldn't have fewer resource areas. Under exceptions, we don't have the language about exemptions for agriculture. Under applications, we have some outdated language about how to use consultants. And that was some of the feedback we got from Attorney McGregor was that the language is outdated. And so the MACC model bylaw has updated language about how commissions can use 53G. Does everyone understand what 53G is? So 53G is a state law that when we're reviewing an application, if we feel that we need expert guidance, we can hire a consultant at the applicant's expense, like a third-party reviewer, such as Emily Stockman. And so we have that authority under state law. We have that authority under the Wetlands Protection Act, but we should probably also have it consistent in our bylaw with the most up-to-date language. Under the section for notices and hearings, there's some minor tweaks we'll look at, and there's also some minor tweaks under the section for permits and conditions. As you may recall from our regulations, one of the things that we require applicants to do is to avoid, minimize, and mitigate. And Attorney McGregor sort of questioned whether we really had the authority to require that because the word mitigate isn't in the bylaw. And we got the opinion from Beth Goodman that she felt the language in the bylaw was sufficiently broad enough that mitigate did fall within the categories of allowed requirements. But you know, out of an abundance of caution, we could add some of that language. And then the section under enforcement is a little confusing. There were some things added on later into that bylaw that are kind of redundant. And I think it could use rewriting just to make it less confusing and more condensed. And then there's a few other little minor wording tweaks. And then what else do I have here? So the changes in the draft I'm going to pull up in a minute basically is suggesting amending the current bylaw with some corrections and additions, adding a few values that are now commonplace in most newer bylaws, rewriting the jurisdiction section to make the resource areas consistent with how they're used today, because again, things like riverfront area and bank are missing. And then there's a few other minor changes. And what else do I have in here? So, I guess one of the advantages of taking this approach would be that it's really just focusing on how can we make this bylaw more enforceable and defensible now. And it won't change our permitting approach or requirements for landowners. So it's kind of a simpler, more limited approach. And because it would not be requiring any major rewrites of the bylaw, updating the regulations to match it would be very easy. It'd be minor changes. So
why wouldn't you add in the climate resilient information? There's some references he gave us that's pretty clear about wording that could be in there that seemed pretty simplified.
So the version that we distributed, I'm gonna pull up a document. So basically we have two drafts, right? We have like all the bells and whistles version, which was the version that we put up on the website in July. And that has the climate resilience language, and all the MACC bells and whistles, including stuff from the climate resilient project that MACC and McGregor, Legere and Stevens and the EEA did. So again, I guess my thought about it is that's a decision point. I thought, why don't we look at this first and get an idea of, what is broken, what needs fixing, and then we could decide, which version we like better and, which direction we want to go. The other thought I had is, we could amend this since we're talking about a pretty short window of time between now and the special town meeting in January. It doesn't give us a lot of time for community outreach and education. So one thought I had was doing a much more modest revision just to kind of fix the most broken things. And broken meaning, allegedly broken, but let's say the more selective improvements. And then, nothing bars us from coming back in a year or two and, doing another revision. Okay, so here's section 1. Can everybody see this? Is this big enough?
Yes.
And just for people who are just joining the meeting, this is our existing bylaw. And where there's red, it's where the language is changed or proposing changing it. And there's comments. And I have this up on the website, so people can access this by going to our town website. So here, everything's the same. These are the values. These are the purposes of the bylaw. We talk about protecting resource areas because they protect these values. It's analogous to the interests that are listed in the Wetlands Protection Act. And the recommendation is, rather than water pollution, saying prevention of pollution, because that's a broader definition that also includes like soil contamination. So we have aesthetics and historic values as two of our values, and MACC does not recommend these as values because they're not really firmly tied to environmental science. They're sort of softer, squishier, more cultural values, so a little harder to set standards for them. So I have those crossed out, but that is a debatable topic. And then MACC recommends adding rare species habitat. And then this paragraph here is from the MACC model bylaw, which just basically, reiterates what the purpose of the bylaw is to utilize home rule authority to protect resource areas and additional values that are going beyond the Wetlands Protection Act. So making it explicit that the bylaw is intended to be more protective than the state law. And then under jurisdiction, this is where kind of, you know, I took a stab at trying to clean up the language. Now we could rewrite this. And if you look at the version of the bylaw that I drafted, the July version, it's completely rewritten, but it protects the same resource areas, just worded differently. Here, I'm trying to preserve as much of the existing language, but I added vernal pools and bank just to make it explicit that vernal pools and bank are protected. And I took out the word subsurface because that was so confusing for streams. And I put perennial or intermittent because we had decided that we were interpreting the word subsurface to mean intermittent streams. And then I added the 200-foot zone around any perennial stream, which is what we call riverfront area. And then everything else is the same. And then this language comes from MACC, which, you know, basically just says that resource areas are protected even if they don't border surface waters. So you don't have to be a bordering vegetated wetland. You don't have to be bordering land subject to flooding. There can be isolated resource areas that are not bordering other wetlands. So any questions about that?
No.
Okay. Then under exceptions, I didn't muck around with this except for to add the language from MACC about the exemptions for agriculture. So everything, emergency projects are all the same. And then here under applications for permits, this is where, you know, yeah.
Can you go back up to the exemptions part?
Yeah.
The last part, other than stated in this section, the exemptions provided in the Wetlands Protection Act shall not apply. And I'm wondering, so we have exemptions in our, under the Wetland Protection Acts, minor exempt activities. And in our regs, we also define those. And how I interpret this is that this would nullify those exemptions, but maybe I'm reading it wrong.
I believe that if we state something in the regulations, it isn't nullified because this language is in our current bylaw and we're still allowed to adopt exemptions, Scott.
We flagged this and just, I think that just asking that question and coming back to it would be great. Thank you.
Yeah, that's kind of illegal. We should ask a lawyer.
Thank you.
I think the reason for doing it this way is that those minor exemptions might change. And so this gives us a little bit more flexibility because it's easier to update regulations than it is to update the bylaw.
Yeah, I'm just wondering, since we have regulations in place and then we're looking to put this in place, I would hate to see this now being the most recent nullifying the Wetlands Protection Act, minor exempt activities, as well as our own regs. And that's how I interpreted this when I read it.
Anybody else have thoughts about it?
I think it's good checking on that. I think I know what you mean. Just that here you say it's only in this section, and then we have other possibilities in the regs, and as long as it's
So it could be shall not apply unless maybe specified in the regs.
yeah, if that's allowed, that's sort of a
Right.
option.
I'm sure it is. I'm sure we can, but I'll make a note of it.
Yeah,
Question. Okay.
Thank you.
Okay. So under applications, our bylaw, you know, was written at a time where it's a little confusing, but it mentions notices of intent. And the way that MACC writes it is just any application, if they use a more general language. So my recommendation would have been to adopt MACC's language. And again, you see how I'm adding these references to CMR 10.00. I added ANRADs because our bylaw doesn't mention ANRADs. So just for all an abundance of caution and clarity. And, you know, I guess the other question when we're talking about applications, I'm just going to make a note here is, you know, we talked about administrative approvals. And, you know, we were sort of advised by council that we don't need to mention those here, but, because they're not a permit. But, if we want to make them a permit, then we would have to add some language here for that. And then there's a section in our bylaw, which is interesting. That's not in the MACC model that says if in the judgment of the commission consulting. Oh, no, I'm sorry. This isn't the section. So this is the section about consulting. And as you can see, it's just like a sentence, 2 sentences about consultants. Whereas MACC has 1, 2, 3, 4, 5 paragraphs. So I just incorporated here straight the language from MACC. Is that clear?
Mm-hmm.
All right. And then failure to pay a filing fee shall be sufficient grounds to deny the application. Commission may waive a filing fee. That's all from the MACC model and it hasn't changed. Then going on to the next section, notice and hearings. Again, one of the things that we get feedback from people is how expensive it is to do certified mail return receipts, and our current bylaw sort of requires it. It's either that or personal hand delivery. So if we added certificates of mailing as an option, then people could do the certificates of mailing, which are much less expensive and it would save applicants money. So the, you know, the downside of it is people don't get certified mail, but in this day and age, you know, do people, you know, it's a nuisance to people sometimes having to go to the post office also to pick these things up. So getting it delivered to their home may actually provide better notice. So I would support adding the certificates of mailing. Even though it's not in the MACC model, I think it's, you know,
I think it would be in the new MACC model because everybody does that, or a lot of people do that now.
no, it's not. It's
I
not.
know, but I mean, it should be in the next version that they do.
Yes. And then there's this language in our current bylaw, which is in yellow. And I added this green language. So right now, and Janice and I were talking about this, the way that the state law is written for an RDA, you're supposed to have the hearing open. You don't have a hearing, you have a meeting. You're supposed to meet for an RDA within 20 days of receipt, and you're supposed to issue the determination within 21 days. So it has to be kind of one day. And it's a little confusing because there's nothing in the state law that says anything about continuing a meeting or continuing a hearing to another date if a commission felt like they needed more information. So I believe you can continue it because it doesn't say you can't, but there is this kind of issue about closing the public hearing. So if you have an applicant who consents, I think if the applicant consents, you're allowed to continue it.
And what I was telling Miriam that we had happen in Hadley is that it was getting into this season where people wanted to get work done. And so they'd send in their request for determination, and we met once a month, and we couldn't meet that 21-day deadline. And I'd ask them, is it all right if we, you know, set you up, you know, after the 21 days? And they said no. So we had to hold extra meetings specifically to meet the state requirement of issuing a determination within 21 days from receipt of the application.
And we've had to do that. I remember there was not this summer, was last summer, I think, or the summer before, there was an applicant who had an RDA and they weren't willing to wait more than 21 days. So we had to schedule another meeting. But I believe, and this is where I think we'd want to get a review from council, MACC says that you can get an extension if it's authorized in writing by the applicant. And there's also a court case about this that I had a discussion with Donna McNichol about it a while back. But that had to do with a notice of intent. So I'm not really sure. I guess I feel like this language may work, and we would just, MACC has it in their model, so they must think it works. And we would just need to get another opinion from a council who is reviewing this for us.
Okay.
Yeah, I ran into that in Amherst a couple times where there was just no way I was going to be able to get the permit out within 21 days of the close of the public hearing. And I know I reached out to Mark Stinson, and that's exactly what we did. We just got in touch with the applicant and said, is it all right if we get the permit to you in 5 days instead of tomorrow when I'm supposed to? And if you just send me something in writing that says that it's all right, that the permit's going to be a little bit late. That's what Mark Stinson recommended, and that's what I know I did that at least 2 or 3 times.
There are a lot of towns, commissions that actually have an extension consent form. And so they ask the applicant to sign it. You can't enforce you can, I believe this is what I think is the case. You can ask an applicant to sign it. You can't force them. So if they agree, great. That gives the commission more flexibility in scheduling. But if they say, no, I want my permit in 21 days, then we have to comply.
Right. That's the same with asking them if
It's
they
always
want
at
to
the
continue
discretion.
the
It's
hearing.
voluntary, and it's at the discretion of the applicant. Can't be compelled by the commission. Okay, so that's all that. So on coordination with other boards. So this is again stock language that all bylaws tend to have. Ours, the language hasn't changed except that we don't mention ANRADs. We don't require feedback from other town boards. What we do is we put our applications up on our website, and our assumption is that if a town board has comments that they would respond because they have access to the applications. Then permits and conditions. Again, this is just like little wording changes. And here's the language I was talking about. The commission shall take into account the extent to which the applicant has avoided, minimized, and mitigated any adverse effects. So again, that's from, that allows the commission to then, use that as an analytical tool for understanding, like an alternatives analysis. Remember, we talked about how we want applicants to consider all reasonable alternatives. And so the goal is that they minimize or avoid impacts, or if they can't avoid them and there's the only way they can do their project is with the impact, that there's some effort to make a mitigation.
Hey, Miriam, I'm wondering, maybe a little bit before, I'm not sure, maybe I think maybe I progressed past this, but the new section about kind of cumulative impacts where we
Right
talk
here.
about
I think it's
whether
right here.
permitted, unpermitted, or exempt. And
This
I'm
is the
wondering,
language from MACC.
I'm sorry?
This is we're looking at right here. Yep.
Yeah, right there. So the red, so the new part where we talk about unpermitted or exempt activities. And I'm wondering when we would ever consider exempt, like the cumulative impact of an exempt activity where we're already saying that's exempt. So I thought that one might warrant some further conversation. And the part about mitigation, I think mitigation is great to have in here. I wonder if they'll that I'm just would like to flag that I think we might need to follow up on that in terms of either regulation or be a little bit more explicit in the bylaw about what mitigation actually means. I know sometimes it means like kind. I think sometimes it means we try to get more like 2-to-1 mitigation or further, and different agencies have different regulations, I think, when it comes to mitigation. So I'm just flagging that's a whole area of conversation, and it references mitigation several times in here. again, I fully support having mitigation listed, but I think it might require us to be a little bit more explicit, either through regulation later on or as a part of this bylaw, to really try to spell out what we mean.
So I think, so in the conference today, sorry, with McGregor, I think most of they had some pretty strict mitigation stuff, but it was all in their regulations. The details.
Our regulations do have a lot of information about mitigation.
That's where they put it. I mean, there were some pretty strict things that they had in their tables there.
That's where usually the way it's written, Scott, is that it's the freedom to look at mitigation is in the bylaw just by mentioning it here, but the actual standards and definitions go into the regulations.
Yeah, and that makes sense to me. I think it would be, since we have regulations in place that talk about that. Now we're putting a bylaw, eventually proposing that for consideration. So I guess I'm just flagging that this is, maybe we're adopting the mitigation standards that have already been done. Maybe it would be different. But I just think if we're going to talk about introducing that here in the bylaw, that we're thinking about how that would follow up in either here or in the regs. And for the exempt piece, I think that would be good to come back to, because I'm not sure how we would think about the cumulative impact of an exempt
Trying
activity.
to highlight it. It won't let me highlight it because I got
Okay, no worries.
So,
Thank you.
So I think the whole point is just, it's a placeholder. So the bylaw has language. Bylaws tend to be very terse. They don't get into a lot of detail because it's expected that they're going to get fleshed out in the regulations. So this is, right now, if you look at the language in our bylaw, it says for failure to avoid or prevent unacceptable effects. And so by changing that language to avoid, minimize, or mitigate, it's kind of creating that three-tiered analytical cascade, if you will, that is sort of standard in environmental regulations, as you know, that it's avoid, minimize, and mitigate is kind of all over the place in environmental law. And all sorts of federal statutes have that. So it's just everybody kind of understands what it means. So having that language mirroring what's in many other areas of environmental law, it was I think the point.
I have a question before you scroll down. I have a question on that same paragraph that commission shall also take into account. And I know we talked about this and I still don't feel like I understand what it's saying, because it seems to me it's saying if we know that you've done damage elsewhere in town, we can use it in how we decide to permit your new application. Is that what you're saying? Or I'm just wondering, I just feel like it's
I think broad. The way I look at it is, let's say, here's a thought. Let's say there's a forest fire, a catastrophic forest fire in Shutesbury.
Mm-hmm.
And a large tract of forest is demolished. And on another property that was not damaged by that forest fire, somebody wants to put up a mall or housing development or something where there's some cumulative impact. So, would the commission take into account that half of Shutesbury had been deforested by this forest fire, and there'd been widespread environmental degradation, and so therefore what's on this property becomes more important in some ways? I mean, like, how would you put your blinders on and ignore things that were happening in the watershed? It's not that we were holding the applicant accountable, but that, if there are changes elsewhere that may have a cumulative impact, we might want to take that into consideration.
As long as you're still within your area of jurisdiction, which is just limited to Aura and 200-foot river.
Right, exactly. But if there was, let's say, degradation happening or environmental compartmentalization or whatever elsewhere, and we thought, that makes the value of this particular wetland area more important, how could we not pay attention to that?
Yeah, but in the other way, just thinking into the future with different commissioners reading it, whether they'll read it like I'm tending to, like, there's a repeat offender in town. They come back with a new permit application, a totally different area from anything that they've been, screwing up elsewhere. And does that give the commission the right to say, no, we're not going to let you do your project here because you did other degradation, either permitted or exempt, elsewhere in town? I mean, or a watershed, so that's outside of town? I just worry that it's too broad. I see what you're saying, and I agree, that's a good idea. But I think it needs a little more specificity, perhaps. I'm just afraid of it being misused, to deny a project by saying, well, you've already done damage over here, we're not going to let you try again. And I don't know if you can do that. That just seems too broad to me.
Well, I would say
Yeah.
that we can't deny a permit unless we would have, compelling evidence, right?
Yeah, right.
And they'd have to meet that evidentiary standard. So, again, it's kind of hard to know because we're making up hypotheticals.
Yeah, right.
And it's hard to imagine that building a house or a residential project would be so cumulative but I guess this language is looking at potentially areas of Massachusetts where people might do really big commercial development where there could be huge kind of watershed or resource area impacts. So I think that's where this language comes from. I don't know. So your concern is whether this would be used to punish somebody?
Yeah. Yeah, whether you could say, well, we know, you screwed up before and we're not going to give you another chance. I mean, I think that's, and I don't think that's very legal. So I'm just concerned that
I guess I sort of feel like, first of all, there's a statute of limitations on past violations, right? And you can't punish somebody for an expired violation.
Well, it doesn't say that here. This is pretty broad. It's past activities, permitted or unpermitted. I don't know. Anyway,
I think this is the language that has come out of court decisions around how you define cumulative impact, Janice.
Okay.
So, I think that we would probably need to really be careful because if we butcher it, it may make it useless or make if it isn't, because this is kind of mirroring other legal decisions that have come. And if we just hack this up, then this could be uninterpretable. I guess I sort of feel like it's already understood. We can't do things that are illegal. We can't punish people for things that statute of limitations has already expired on. And there has to be kind of the fairness doctrine, right? It has to be
right.
It has to be proportional, whatever is being required, and there has to be evidence to support it. So it'd have to be a pretty strong argument for all of that.
Okay.
I think cumulative impact is kind of a hard concept, but I think MACC has really advocated for commissions hanging on to it as a standard because it's more protective than state law. And there are times where communities do want to deal with cumulative impact.
I guess I'd feel better if it actually said cumulative impact somewhere in there then.
Yeah.
I understand it from the big picture that you're talking about. I just don't want it misunderstood for small projects and whatever.
All right, so this next several sections are taken straight out of MACC. So this language was not in our current bylaw, but this is kind of standards that MACC is advocating be put in bylaws. So the first one is that we can waive design specifications, provided that we find in writing that there are no reasonable alternatives and that avoidance, minimization, and mitigation have been employed. So this is kind of that, consideration of reasonable options that we talked about in our regulations. I think this is very reasonable.
Mhm.
And it makes it explicit that, we can do waivers if we are finding a fact, based on a finding of fact. And then here's a section about aura, because again, the state regs don't talk about how the aura is protected. But this spells out that the aura is presumed to be important and that adverse impacts can lead to loss of groundwater and water quality and wildlife habitat, which are values of the bylaw. And that the commission has the authority in its regulations and other standards to include setbacks and no disturb zones and other work area requirements. So those are all some of the things that we've established in our regulations. And this is just basically saying we have the permission to do that.
I had a couple questions. I can't see it on the screen, but I think by the way, the comparison document you pulled together, Miriam and Janice, was awesome. So thank you that must have been a ton
Miriam.
of work. But it was really super helpful.
Which one? I think there were a couple of them, weren't there?
The red and green.
The red
The
and
red
green.
and green one.
Okay, thank you.
But I had two questions. One was on, I think it was in the part where we had talked about, I think it started in reviewing activities within the buffer zone. The commission
Yeah,
shall
right here.
pursue the buffer zone. Yep. And then it talks about setbacks. It says the commission may establish in its regulations, design specifications, performance standards, and other measures and safeguards, including setbacks.
So
And
that's confusing because it sounds like something out of zoning.
Well, I don't know. Well, I mean, in our own regs, we talk about the buffer zone itself is a resource area and kind of a setback from the wetland, and so it's not really clear. Are we talking about a setback from the buffer zone even further out?
No.
Or
It should be, I think that this is referring to like establishing no disturb and no build areas. So I think that's what that means. Not a setback outside of this is not extending jurisdiction, Scott.
okay, and that's the only.
Jurisdiction is 100 feet or 200 feet if it's a perennial stream.
Yeah. So
It is confusing, and maybe this word, should get changed because people might think that it's sort of adding a zoning, because we talk about setbacks and zoning.
right. I just wanted to flag it, so maybe we could come back to it. And then I think there was one other question I had that was confusing to me. It was one of the last paragraphs that we had inserted. It began, the commission shall presume that all areas meeting the definition of vernal pools, including
I didn't actually put that in here in this draft.
Oh, okay, so that's out now.
Yeah, because I figured,
I withdraw
we have all that language about vernal pools in our regulations. So I don't know that we actually needed it.
That was my question. Thank you. Withdrawn.
You can probably take out that, the including setbacks entirely, because you've got.
It just zoomed in on me. Let me try
Yeah.
to get it smaller. I'm sorry. Got too big all of a sudden.
Woo.
Can you guys hold on for 1 second? I just need to say something to my husband for a sec. I'll be right. Okay, thanks. Okay, is this too small or you guys can see it?
That's okay.
Okay, so was there more here before we move on?
Well, I was just gonna say, you can just almost get rid of setbacks there, because you've got including no disturb areas, no build areas, which is
Yeah.
really what the setbacks are anyway, right?
Right. That's my understanding.
Yeah.
Okay, so
I have a question still on something that's been appearing in different sections, and On the next sentence, a permit determination of applicability or order of resource area delineation, blah, blah, blah. It either says a permit or a permit application, but that's not defined anywhere. So to me, you know, we're assuming that means a notice of intent, but it doesn't say that anywhere.
Yeah, you know, that's kind of, again, what, I'm looking at the MACC model, and I don't
Yeah.
know exactly their reasoning why they don't call it a notice of intent unless, you know, they're considering that a notice of intent is an application. A
Yeah, and this permit is the order of conditions, but then
Right.
why do we have, I was just wondering if you could put into the definition that a permit application is an NOI, RDA, blah, 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 sort of, you know, all those
That
things.
this is where I had a question about it,
Okay,
because, you know, again, you know, I don't see this in these bylaws. They always have this vague language.
yeah,
And I think maybe it's because a permit could be more things than just an order of conditions. A permit could be a letter or a statement from the commission, permitting something. Right?
still, I mean, but why, you know, I know why you added the determination in the ORAD, it's because it's not stated elsewhere, but I don't see, it sort of limits the word permit or permit application to then just add, you know, the request for determination and the ANRAD and stuff. So it seems like if you could just say a permit can include blah, 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 or permit application includes request for determination, notice of intent, ANRAD, etc. It's awkward to me, and I know it's in the MACC version, permit, or permit application, but it doesn't
Yeah, it's a
actually say
very
it.
general
Yeah,
language that, because, and it may be because the reason for this is that if I were to talk to like an ordinary person
yeah,
who doesn't spend a lot of time with this, and
yeah,
I said a permit, they would
Yeah.
kind of understand what I mean. But if I say an order of conditions, they probably are going like, what? Or if I say
Yeah.
notice of intent, they're going to go, what's that? So I
yeah.
think like an application and a permit are language that is kind of plain English
So we should just lump the others into that.
in a definition, you mean?
Yeah, because otherwise, what does a permit application mean other than a notice of intent? Generally speaking, and I agree, permit application's a lot simpler term, but I think somewhere in the bylaw, it should actually say, you know,
Yeah.
including but not limited to,
I know,
perhaps.
yeah, I mean, I agree. I when I was getting new all to this, I remember
Yeah.
reading through this bylaw and going like, what is a permit?
Yeah,
Nobody's talking to me about permits. I just know about NOIs. Why is it doesn't say
Yeah.
NOI anywhere? So I
yeah,
get, okay. So
Okay.
then, here's a option, a statement that says a permit may identify perpetual conditions.
Mhm.
Basically, this is the language that makes it clear. And I believe that this is already in state law. So this is just making it also clear under our bylaw
Mhm.
that you could have perpetual conditions.
Okay.
And then here again is this whole permit determination or any other order thing.
Yeah.
And then, and so we have to figure that out. Okay.
Mhm.
Be consistent. And then this is also from MACC, no work. This is basically requiring the registry that, or or permits. So this would be again, an order of conditions. Or ORADs have to be registered, recorded at the registry,
Mhm.
which is also required under state law, but it's just making it also clear that a permit issued under the bylaw also must be recorded. So I think that is important.
Mhm.
Okay, and then this ANG language under regulations, piece that we didn't do was, our current bylaw doesn't require the filing with the town clerk. We did file with the town clerk, but I think it's important to make that clear for future generations of commissions. And
I think that's good, Miriam. Maybe we could be a little more explicit on the effective when voted by the commission to, I think it's when we pass it, right? And so,
When it's approved,
I know, I don't think it's effective until it's filed with the clerk.
well, I'm just saying, like, we could vote it down.
I think it should say approved, right? Effective when
Right,
approved
maybe
by the
voted and
commission.
approved by, or,
Yeah, and
Approved.
file.
yeah. I think I like Mary's suggestion.
What, Mary?
I just said it doesn't have to say voted, it could say effective when approved by the commission and filed with the clerk.
Mm-hmm. Yes. Okay, that good?
Yes.
Yeah, thank you.
And then again, making it clear that the regulations can include filing fees. Which is in our bylaw and it's in the MA, this is from the MAC language. Okay, and then under definitions, I mean, so what I've noticed is that there's great variability in different bylaws about how many definitions they have. There's no rule of thumb that I've been able to find. Some towns have 1 or 2 definitions, and some of them have like 20. I think that definitions are better suited for regulations, and you know, maybe just a couple of the most 2 or 3 of the most important definitions should be here. And maybe the one about applications, what an application is, needs to be included. So alteration is a really important definition. And every bylaw that I've seen has this in their definitions. What does alter mean? And our definition is absolutely the same as what MACC has, except MACC has this last piece, that an alteration could be an incremental activities that could have a cumulative impact. So
I think that seems good.
Yeah. So everything else is the same. So under security.
Okay, just on the definitions,
Big
are you
topic.
gonna put them in alphabetical order? Because
No.
you have it agriculture, person, consultant, and alter.
Yeah, because I added things.
Yeah.
I actually don't think it was an alphabet.
No?
No, it wasn't alphabetical. So I don't know. I mean, you know, it's really weird to me that like some bylaws like will define 2 or 3 resource areas, but not all of them. Like, I don't understand the logic of that. I feel like if you're gonna take some of the resource areas, you should define every single one or none of them really, and leave it up to the regulations to define them.
Unless there's something different and unique in the bylaw. I mean, anything that's very specific to the bylaw, there should be a definition in there. If it's not something that's standardly used,
Okay.
you know,
Well,
it has a different
I haven't been
definition.
able to find a
Yeah.
definition that seemed so critical. I don't, maybe I don't understand why the reasoning, and maybe there's some secret reasoning.
Secret reasoning.
Yeah, I mean, I don't know. Maybe that's a question to ask in the MACC is, you know, which RAs should you define? I don't know. So then under security, remember there was this whole concern that Attorney McGregor had about a conservation restriction, and that you want to make it really clear that the commission can't force somebody to provide a conservation restriction, because that would be illegal, but it could be offered. And so MACC has this language. They have the word accepting, and then they have this statement down here.
Okay.
As you may recall, we adopted regulatory language to fix that, because of course we would never force somebody to accept a conservation restriction. So we're just making that clear, but we can clean that up with this new draft of the bylaw.
Okay.
Okay, and then here we're how are we doing on time? So here's the enforcement section. So all of in the MACC model, they start with this statement. And, you know, it's a little redundant because this also is sort of stated under the jurisdiction section, but every bylaw I've seen restates it. So I think that this is considered to be a sort of necessary thing under enforcement to make it clear that it's reaffirmed under enforcement. And then the right of entry, which is included in the Wetlands Protection Act, right of entry, is always subject to the constitutions and laws of the US and the Commonwealth. So adding that language makes it clear, we understand it already, that right of entry is always conditional.
Okay.
Everybody understand that? And then here, MACC includes things like phone calls and emails and other informal methods to make it clear that commissions have other tools at their disposal to advise and enforce about the bylaw. And so this just makes it clear that emails and phone calls and informal communication is also allowed. It doesn't all have to be an enforcement order. The other change down here is that because of case law, you can't have language that says a fine of not more than $300. You have to have a specific fine. You can't have it be variable, like a sliding scale. So I put down $300. Some commissions do $100 for the first offense and then $300 per each subsequent offense. So I think that's a decision point to make. Okay.
Can you also have different amounts for different levels of offense instead?
You can. I haven't looked at how any commission and any bylaws they've looked at. I don't know how. I mean, what I've just seen, I think maybe there's a couple that did some very detailed kind of table. Most of them just have it left to either $100 first offense, $300 second offense, or something like that.
Yeah, okay.
Or
Yeah.
just that. So,
I mean, I wonder about that sort of idea, just to do like first offense, $100 to maybe they were, just accidentally screwing up versus a repeat offender than having to pay more.
that makes sense to me. Do you guys like that idea? I can alter that.
Yeah, no, I like the idea of maybe looking into a little bit what other towns do for sort of a range like that. Something that's a little smaller than 300.
Okay.
Yep.
And then here's where I think that this section has to be cleaned up. There's this amendment that was passed, I don't know, like in 1990 or 1995 or something, where the town added non-criminal enforcement under 21D. So what they did when they adopted it was they just repeated the whole alteration language. Like, I don't think that's necessary. I think you can just reference it, say alter shall mean as defined in section 9.
Yeah.
I don't see that as being adding anything except for more, you end up looking, I end up find myself reading it thinking, well, is it different from section 9 or why is it here? I don't know. And then here they have again, failure to provide a written application affecting resource areas, and they list the resource areas again. So I don't think we need to do that. I think we just reference section 2, which is where all the resource areas are.
Now, do you still have, is this a section, I think it still talks about $50? Yeah, punished by a fine of $50. So how does that work with the section that we were just talking about above it? Yeah, under right there, first paragraph.
Well, have you ever worked with 21D before? I thought you'd know, Janice.
Yes, yeah, but I'm just wondering, I mean,
My
first you're
understanding
saying
with 21D, which is a whole different sort of non-criminal enforcement,
yeah,
you have to have a defined fine, is my understanding. And with this
yeah,
is criminal enforcement, I believe.
is it?
I believe it is. that this is.
Oh,
an
okay, because it
alternative-
says
this
in
is an
alternative. Oh, okay. All right. So the criminal enforcement, then, that's something that can't be done with ticketing like 21D. You'd
No.
have to, well,
No.
how would you, I haven't done one in a criminal way. You'd have to actually take it to
You'd have to go to court.
housing court or something like that. I
Oh.
think people do.
I think you have
Okay.
to.
Hmm.
I think it would be a whole big thing.
Yeah, okay.
Yeah, I think usually like that typical $300 fine is under the non-criminal.
Huh.
Not written that way in MACC's bylaw. They have it here
Huh.
as
I don't
non.
know.
Okay, so, all right, so
We'll
suffice.
look
it
into that.
Yeah.
So we need to look into it.
Yeah.
Janice, you want to do some research on
Okay, sure.
it? I'm very excited. All right, and then, okay, so this is all the same. Burden of proof is the same in the MACC model in our current bylaw. MACC recommends that you have a section making clear appeals go to court. This is from MACC. And then here again, under section 14, relation to the Wetlands Protection Act, I just added this sentence from the MACC model. The intention of this bylaw, that the purposes, jurisdiction, authority, exemptions, regulations, specs, etc., shall be interpreted and administered as stricter than the Wetlands Protection Act. So you're adding this language so that some court doesn't throw the bylaw out for any reason.
Okay.
And severability, we understand what that is, and that's it.
I had a question on section 6. Which
Section
we,
6?
yeah, the coordination with other boards.
Get to it.
Yeah. And again, I'm just trying to think, like, how does this actually work? Yes, so in this, they were gonna have 14 days from receipt for these other boards to file comments, and the commission shall take that into account. Okay, now you changed it then, but will not be binding. It did say before that you couldn't issue the permit until you'd gotten those comments. So that must be in one of the other versions or something.
Maybe. This is what, if it's in black, it's in the current bylaw.
Yeah, right.
So, we've talked about this before that, if you have to issue a permit in 3 weeks,
That's why I was
and
wondering.
they have 14 days, that's a very short period of time. But I think that, we're not going to take action before 14 days is really my understanding, that we would wait at least 14 days in order to give them time to have comments.
Oh, good, because the way I read it before was that the commission couldn't take action. Yeah, until you've gotten their comments, and hopefully there were no things that were going to extend your review time or something. Okay, so I guess that's okay. There was one other thing. Okay, so this is a little different. I think there's someplace here that talked about having to have plans, and no, it's not. I guess that was another section.
Designs.
Well, just that you had to send them copy of the
for notices.
yes.
So on our current bylaw, one of the things that's weird is that it actually, I'm sorry, let me scroll. It actually says that in the abutter notifications, you're supposed to send the copy of the plan. And we've had this discussion that that's just impractical. You can't
second
do that.
paragraph.
So we want to fix that, obviously, because we're not asking people to do that. So town council has said that as long as abutters are notified where they can get access to a plan, we're meeting the requirements of the current bylaw.
Okay.
So we put the plans up on our website, and on the abutter notifications, we have information. We say, you can access the plan at this email link or by contacting the commission.
Okay, good.
So we have both options. So if somebody doesn't have internet access and they want to come to town hall, or they want to get a copy from town hall, We have
Okay,
that.
yeah, good, because I wondered about that, like, we have to send out plans to all the abutters. Okay, good.
So I think that was, where's notices? It
I
would be
don't
under,
know, it was around
you
there
were looking at
somewhere.
notices and hearings here. So it's here.
Oh, yeah, like the fifth sentence or whatever, shall enclose a copy of the application with plans.
Where is it? I'm not,
In that first paragraph, about halfway down on the right-hand side. The notice to abutters shall enclose a copy of the application request with plans, right where your cursor is.
yeah, so I think that's should get changed.
Yeah,
I think it should probably be, should enclose a probably a description.
yeah,
And
of
they can
where
get
they
it.
can,
Yeah,
yeah, okay.
that's what I hadn't, I thought it didn't have this. So
Yeah, that's
I
better.
think that's what it should say is
Yeah,
description. Basically, what we do now is like a 1-sentence description and then information about how you can access the plans.
okay, that's good, thank you.
Okay, thank you for catching that. I missed it. So should I take this off screen share? So what do you guys think? What do you want to do? What would be the best? Let's think about what our best approach would be. Now that you've had a chance to look at this, and if we want to go and have another meeting and go through that fancy, all the bells and whistles, we can do that. I can pull it up now if you want to look at it. Your choice.
I personally, I think just based on everything we went through with the regulations and how the town seems to really want this bylaw updated, as soon as possible, and that the special town meeting, or if we're talking January, I just feel like what we just looked at is maybe where at least I'm at right now for an updated bylaw. I think all the bells and whistles, all the climate change stuff, we can, maybe talk more about over the next however long, and decide if eventually in a few years or whatever, we want to update the bylaw again. I guess I don't see the emergency need to add all of that in right now, but I don't know how other people feel about it.
I feel the same way. I think we've flagged some things that I think would be good to get, our legal advice or review on, but I think we're like 95% of the way there. So maybe there's a way we could get, additional legal review of the things that we've flagged, but I think it's a pretty good product. And again, hats off to the folks who have taken the initiative here to draft it, to you, Miriam, and others, Janice and others. So thank you.
Thank you.
So I think,
totally
I
agree.
initially thought we should do
Yeah.
the whole thing. It was in
Go ahead,
favor of
Brad.
that. I think after sitting at that meeting today and looking at how many other people simply updated what they had to add to it, I think that I do think that a shorter one is probably more beneficial now. And the only thing that I would add to the one we're doing is the climate resiliency piece, which is pretty well all spelled out already.
So
But I agree basically that we should go with updating the
Yeah.
draft that we have here.
what do you think, Robin?
I I agree. I'm based on our discussion tonight, and the few changes that people mentioned, I like what we're seeing.
I agree. I mean, this is the approach I feel like I having a really comprehensively different bylaw language that maybe people will have lots of questions about, maybe will be concerned about whether it would be approved by the AGO. I mean, the language that is in this draft with those little tweaks that we just talked about, we can fix, or we can get a lawyer's input on. We know all of that's going to be approved by the AGO. it will be approved by the AGO. None of it is controversial. None of it is outside the box, or different from what most other towns have. One thing, we could do with a nod toward climate resilience is just as a value, we could add climate change resiliency as a value and leave it at that, which is just kind of a, adding that, that is kind of how we understand why all of this is important. One of the things that I liked about the presentation Mary and I attended today was that Attorney McGregor was talking about, needing to decide what's important to you as a community. What are you concerned about? And then, how do you protect things, working back from what you care about? And I think people in Shutesbury really care about climate change. And so I think that they would like it to see a bylaw that has at least one sentence in it that says climate resilience. The other comment that I had some conversations with Pat Garner about this when we were doing the regulations, and I asked him about, a bunch of climate change language that we could put into the regs. And, maybe he's a little old school about it, but he was kind of saying, well, we lost Scott.
Yeah.
Yeah, I admitted him.
Hi, Scott, back again. And what he was saying is, all wetlands protect against climate change. You don't have to say it for it to be true. So, but adding it as a value, I think, is like an educational piece for the community, also letting them understand why this is important and why they should care about it.
Yeah.
I
And
think
then
that-
do more details in the regulations later on.
Yeah.
Yeah,
I think
I
it
think,
gets you the foothold or the foot in the door to be able to do more with climate resiliency, and perhaps some of it in your regulations. For instance, being able to use a more current model of the rainfall data, and just starting with things like that, and then maybe culvert sizing and some of those other things.
Yeah.
I think it's nice to at least, if you've got that in the bylaws, then that's
Yes.
the start of what you can then talk about in the regs.
yeah, I'm okay with doing it that way.
I think the thing that McGregor and Legere were recommending, and this is where Pat Garner had an objection and a difference from them, is that some of the towns had, and I think it was Arlington, put in their regulations that applicants needed to prove that they were incorporating climate resiliency into their designs. And so what Pat was saying, that's a really squishy standard that's very hard to define. And a good wetlands water management design will add to climate resilience, but making people perform to that standard when it's hard to define is a tricky thing. So that's why we did not put that in to the regs, because he said, just do good wetland delineations and good make good permitting decisions, and that will be good for the environment and good for climate change. Okay. So I agree with all of this. I feel like, also we got to think about now, I think, a timetable for what this looks like for rolling this out and what we want to do. I mean, I can clean up this draft a little. I feel like at this point, we've got some questions for a lawyer. So we would need a legal review before we could really have a final draft. I'm a little nervous and uncomfortable having a public hearing until we've had a legal review, because I sort of feel like, what are we asking people to comment on if we're going to change it because the lawyer tells us we have to change it? I'd like to get sort of down to like a best draft. Maybe not the best draft, like our best stab at it after a legal review, and then have a public hearings. So we need to ask the select board for a legal review.
Yep. Sounds like the next step.
When would we want to
Agreed.
have public hearings? And how many? 1, 2?
Could
To
you
me,
start
it's a
with
pretty
one?
short. What?
I'm sorry, go ahead, Beth.
I guess, I don't know, I was gonna say it's a short document, but also, providing two opportunities, two different times for people to come to a meeting, just in case they can't schedule going to one, so then they,
Yeah.
go to another one.
I was thinking two, just to give more opportunity.
So, we only typically meet once in, Scott, you had your hand raised.
Yeah, I was thinking that we could start with one and see the type of feedback that we're getting and see whether or not a second would be needed. I'm just trying to weigh out I mean, I think there's some urgency in trying to get this before, and of course, it would go to town meeting where it would be discussed anyways, but so I guess I'm thinking
Here are
more
the-
of an
So here are the issues. I don't know when they're planning on having the special town meeting, but let's say that they're hoping it's, let's say, the middle of January. So we meet right now on December 7th, and then we meet again on January 11th. And I'm,
So December 7th is the first Thursday.
yes,
So I think we meet on the 14th.
what?
So December 7th is the first Thursday.
Yeah, I'm sorry if I got that wrong.
So I think the 14th is when the second Thursday.
Why did I think it was that? Ooh. Okay. Interesting. Maybe, am I looking?
I just happen to have my calendar sitting here. in front of me.
Yeah, so I think December 7th is too soon. December 14th, I could see us doing it if we get a legal review.
Yeah.
And,
To
and
incorporate it
wanna
in our meeting.
yeah, and we might want to have a short meeting just to make sure that after the legal review, we like what the changes are. I feel like we probably need to have a meeting. So let's say we schedule it for the 14th and incorporate it into our meeting at like 8 o'clock.
I have a CPC meeting that night, and I
Oh.
think I'm probably gonna need to go to that, because I think that's gonna be reviewing actual applications. Or, yeah, I
Uh,
can talk to Mateo about it.
yeah, that might be an important meeting for you though. So let me just check the agenda list. Give me one sec. Why did I think that there was like a December? We have a public hearing scheduled for December 14th, right? So we have two hearings. Ugh.
Mm.
On the 14th, we have 56 Lake Drive. I think that's going to be pretty quick because that's a simple, continued public hearing. And then we have 41 Lake Drive RDA. Oh, because he had to postpone it because he was doing his doc too. So that's also, I have it at 7 o'clock. That's weird. I'm not sure what time. Okay. I'll have to double check them records about that. So, I mean, we could do an 8 PM hearing. But I feel like we might need, let's say we can get a legal review this month. We might need to have a short visit, like around December 1st, or earlier that first week in December, just to make sure we've approved a draft for the public hearing.
Mhm.
And it would be nice to have you there, Janice, at the public hearing. And so you can't make Thursdays. That's the other problem.
I can't do second and fourth, no.
How about the 13th?
Let me see, hold on, sorry. 13th, that should
We
be
could do it
okay.
earlier. What?
I think that's the historical commission meeting.
The 13th.
I think so. I'll have to check my notes somewhere.
I'm not loving having two meetings that week because it's
Oof.
Hanukkah.
Yeah.
I can't. I can't do it.
Yeah, December is pretty hard. I mean, maybe we try to find out when they're thinking of having town meeting. Because maybe we start looking a little bit more at January for this kind of stuff.
That just means we wouldn't be able to have two. That's okay with everybody, but that's, like, if they would, yeah, so.
I mean,
Are
I
there-
do think we need to have one in December, and then a second one in January. If we go to January, we're gonna get tight. We'll probably have to add extra meetings for us to approve any changes and anything else.
Yep,
Um,
yeah, I think we'd have to have it in December.
Yeah, the
Like
13th
the
is,
18th. How about the 18th? Monday, the 18th.
it's okay with me, but what's okay with you guys?
so you're talking about having the COMCOM on the 14th and then do the 18th too?
No.
Changing it all to the 18th. Okay.
Yeah, well, we'll meet on the 14th. Because we have to, because we already have two hearings. Hopefully make it a shorter meeting, and then on the 18th have the hearing.
For the bylaw.
I think that's a better,
What time?
Can everybody make the 18th?
think
Do we
so.
have a time for is it 7 on the 14th and what time on the 18th?
14th is 7. And
Can
the
we
8th,
just do an hour on the 14th? Can we
Well,
just
if
do
we
like
don't-
7
if-
to 8, not add anything else to the agenda if we don't have to?
well, again, I don't know what's gonna come up. I mean, we may have to. If we get a legal review, we might need to go over that legal review on the 18th, on the 14th. And there might be other it depends. I just, we can try to keep it a short meeting. I know. Nobody wants to, that's a tough time of year for town meetings.
What time on the 18th, Miriam, are you thinking?
What do you guys want?
I can do anytime. 6 works. We can do later too, but the marathon meetings till late at night don't work for me as well.
I'm
Yeah, I
happy
think
to
6 would be fine.
6 is fine. Yeah.
fine for me.
Yep.
Okay,
All right.
so I have authorization to request a legal review from town council. Is that where it'll come from?
Sounds good.
We
Yeah.
should at least start there.
They had talked about maybe asking McGregor to do the legal review.
I
I
think
don't know
we
about-
were trying to keep expenses down, but
Yeah, I think it should be town council. Makes
Mm.
sense. Okay. All right. Well, don't know that we need a motion if you give me the authority to seek out. They may ask me how many hours of legal review I need. And I never know how to calculate these. I always don't do it correctly, so,
I guess it depends on the council and how good they are, how much background they have in this particular area. And how much time it will take them to review it, and know whether it's follows legal
I mean, I'm
standards.
assuming 2 hours, right?
no,
I
I
mean,
think.
it's 9 pages now.
Yeah,
not
but
that
she's
long.
gonna have to probably, or she or he would have to go and do some research and look at it. Probably there'd be some background research. I mean, we had originally asked for 5 hours for our regs, so should we say 5 hours?
Start with 5 and they may take you down a few.
Okay. And if for some reason unexpectedly that town council is recused, should we ask for Beth Goodman to do it? Ask the select board to approve her?
That would be my preference. But I think too that if you're sending it to Donna, you need to put a time limit on when we need the info back by. That may make a difference in whether she does it or not.
Okay,
Good idea.
Okay, yep, I'll have to get it to her then quickly. I can clean up this draft and send it out to you guys to see if there are any edits.
Okay,
And if you guys could do any proofreading, that'd be great. And then I'll send it to her. Or whoever's gonna do it. Okay.
Yeah.
All right.
Sounds
So we are, I think we're good. We're meeting, today is the 15th, and we are not meeting again until the 14th at this point.
Happy
Wow.
Thanksgiving.
Yes, you too.
Yay.
happy
Well,
Thanksgiving.
through.
Yeah, everybody. All right, good night.
Don't
Good
eat too
night.
much.